Okay, the separation of church and state doesn't mean we are a godless country. I'm just gonna start with that. Are you freaking out yet?
I'm so scared right now, you shut up!
The reason why I say that is because there seems to be a common misconception going around that says just because there is a separation of church and state means that we must remove God from all forms of public life. This is simply not true, and I think the misconception comes from a failure to understand where our laws come from and what the Constitution is actually built upon. So much so that back in 2022, the Supreme Court had to decide for everyone whether or not a high school football coach could kneel after a game without being fired from his job. To me, this is like having to call a surgeon every time you get a paper cut, and it seems like the doctrine of separation might have gone a little too far. So what the heck is the separation of church and state? Somebody please explain. I'm Jake the Lawyer, and welcome back to Internet Esquire. Well, there is obvious nuance to the case that I just mentioned. The too long didn't read hot take of the day seems to be that the Supreme Court is eroding the separation of church and state, or the Supreme Court is dismantling the separation of church and state. More at 6. Yeah, I guess that's what you do nowadays. You just say when the Supreme Court makes a decision, it's dismantling the very fabric of our civilization. It's a threat to democracy.
This is extremely dangerous to our democracy.
Well, it is true that the Supreme Court has been pulling back from more rigid separation interpretations beginning from the 1960s and 70s. The reason why is because the previous interpretations were unworkable when they were actually applied to real, everyday American life. Fixing a problem of how a law was interpreted and applied in the past does not mean that we're eroding fundamental doctrines that are the fabric of our society. Okay, well, if that's not happening, Jake, what is? How do court work? Well, as the highest court in the land, the Supreme Court is the final authority on questions of law. Its primary job is to interpret the Constitution and make decisions called precedent. This precedent provides uniformity and stability in how laws are interpreted and applied nationwide. This allows lower courts and government legislatures to make laws and try new things because they know what dad is going to say. Have you ever tried that? You talked to mom about it? Did you ask dad?
Son, you know, once you start, there's no going back.
That's honestly kind of what the Supreme Court does. It does this through a process called jurisprudence, which literally means knowledge of the law, where it will look at earlier cases related to a new one that it is dealing with, examine earlier cases and its decisions affecting the interpretation and application of the law over time, and either continue on with those decisions or make new ones based upon how things have been going. Doing this slowly over time is a bedrock principle of a stable judicial system, and it is called jurisprudence. Jurisprudence. Say that fast 3 times. The Supreme Court will let legislatures and lower courts try things and interpret things, and if necessary, if 2 of those lower courts are competing in how they interpret a law, decide for them. It will also look at its own decisions and make adjustments in the same way. And this is exactly what has been happening in recent Supreme Court decisions regarding the separation of church and state. So what is the separation of church and state anyway? Well, on its face, it's fairly simple, coming from the first line of the First Amendment. Congress shall make no law respecting an establishment of religion, nor prohibiting the free exercise thereof. The first part means that the government cannot use its authority to establish a national religion, otherwise known as the Establishment Clause. The second part means that the government cannot use its authority to support one religion over another, or force citizens to take part in any one particular religion. This is known as the Free Exercise Clause. But where is it written separation of church and state? Well, it's not in there, actually. The phrase itself was written by Thomas Jefferson in a letter shortly after the First Amendment was ratified. Writing to a group of Connecticut Baptists concerned that the state might favor one form of Christianity over another, Jefferson wrote them explaining that the Establishment Clause and the Free Exercise Clause work together, thus building a wall of separation between church and state. It is from this letter where we actually get the words, and over time, the Supreme Court took those words and started building them into their opinions regarding the Establishment Clause and the Free Exercise Clause, thereby popularizing the phrase. Okay, so Establishment Clause, Free Exercise Clause. They build a wall of separation between church and state. Correct. But that doesn't really answer why the wall exists in the first place. Well, the basic civics class answer is that it exists to protect religion from government and government from religion. Having a separation means that the government cannot tell the people what to believe, and also that the church or religion cannot tell the government how to govern. Prior to the American Revolution, it was absolute commonplace for whichever government that ruled a nation to also rule the religion of that nation. This was known as the national church. However, as the Enlightenment gave rise to the ideas of natural rights, the concept of a national church was challenged. And it is from the concept of natural rights where we get the idea of religious freedom in the first place. Both the Establishment Clause and the Free Exercise Clause are considered to be foundational natural rights. Natural rights come out of natural law, which is the idea that as the creator of all things, God created an eternal, inherent moral order in the universe when he created it. You might not believe that. It doesn't matter. What's important is that this is the foundational framework upon which the United States laws and the philosophy of its laws is built upon. This eternal moral order, or natural law, is discoverable by human reason because we are made upon creation in the image and likeness of God. While these principles can trace their roots back to ancient philosophy, they were first written down and established in the Enlightenment by thinkers such as John Locke, who wrote that life, liberty, and the pursuit of happiness were God-given rights inherent to every person upon birth. These principles were then adopted by the founding fathers of the United States, who, as men of the Enlightenment themselves, took those principles and embedded them into the Declaration of Independence. I did a whole video on the Declaration of Independence a few weeks ago, so you can check that out, but the core idea that I'm getting at here is that the Declaration itself relies entirely on natural law and the eternal moral order of the universe as the justification for why America can exist in the first place. We know this because it says things like, all men are created equal, endowed by their creator with certain unalienable rights. It also mentions things like divine providence, and the laws of nature and nature's God, and with firm reliance upon the supreme judge of the world. Now, I know what some of you are thinking. That's great, Jake, but the Declaration has nothing to do with how the laws are run in this country. Only the Constitution does that.
You sure about that?
You're not wrong. You're not wrong. You're just placing laws before rights. You see, rights come before law. The Constitution does not establish them. Imagine it this way. The Declaration is the why of America, and the Constitution is the how. So the Declaration, in so many words, says that America can exist because of natural law, and that governments only exist to protect natural rights, which come out of natural law. The Constitution then only needs to be a framework for how these rights are protected. As a result, the separation of church and state is not a right itself. It is merely the mechanism by which we protect religious freedom. Therefore, the mechanism, not being more important than the right, may be adjusted over time, while the right itself is absolute. So to wrap that up, the separation of church and state does not mean that it should deny all forms of God from public life, because the entire concept of religious freedom, which it is designed to protect, arises out of natural law, which arises from the Creator himself. Therefore, recognizing God is not inherently unconstitutional, so long as the government does not establish or coerce a particular religion. Again, you don't have to believe this, but understanding it makes it a lot easier to understand how the Supreme Court interprets law and applies jurisprudence. So with this clear understanding, let's take a look at some key Supreme Court decisions over time and see how the separation of church and state has been built, applied, and interpreted to protect religious freedom. The first major case dealing with the Establishment Clause was Everson versus Board of Education in 1947. A man named Arch Everson sued the government for a taxpayer program that gave reimbursements to parents of kids who both went to public school and private religious schools when they used public transit to get to and from those schools. The court found, however, that there was no violation of the Establishment Clause because the law itself had a legitimate secular purpose or a non-religious purpose, which applied evenly to everybody. Because the reimbursements did not make a distinguishment between private school kids who were going to a religious school and public school kids who were going to public school, it did not breach the wall of separation. In his decision, Justice Black went deep into the origins of the Establishment Clause and the First Amendment, and this was the first time where we get a real Supreme Court opinion that kind of breaks down how the Establishment Clause is actually meant to work. He says the following, and I'm paraphrasing here. The Establishment Clause of the First Amendment at least means this: no government can set up a church, nor pass laws or taxes which aid one religion over another, nor force a person against his will to attend church or profess belief in any one religion. This case set the legitimate secular purpose precedent, which means that laws that may indirectly benefit religion are still constitutional so long as their purpose is non-religious. Then in 1962, we got a chance to see how this applied in the case of Engel versus Vitale. The court found that a voluntary, non-denominational prayer, which was to be read in schools every morning in Pennsylvania, was unconstitutional because it had no non-religious legitimate purpose. Thus, laws designed entirely for a religious purpose are almost by default found unconstitutional because they serve as an effective endorsement of religion by the government, even when they are voluntary. A similar situation happened almost 1 year later in Abington School District versus Schempp, where the court found a statute requiring state-sponsored Bible readings at the beginning of school each day to be unconstitutional for basically the same exact reason. And then along came the landmark case of Lemon versus Kurtzman in 1971. In Lemon, 2 state programs allowed tax-funded payouts to private religious schools to pay the portion of teacher salaries which was used on non-religious subjects. So think math.
Are you good with numbers?
5359260.
He's a genius.
If a teacher at a religious school spends 1 hour a day teaching math, can the state then reimburse that teacher for the 1 hour of math taught because math is not a religious subject? The court said no, finding that the law was unconstitutional because it created an excessive entanglement of government with religion. In its decision, the court came up with 2 new requirements on top of the legitimate secular purpose test, adding that a law must neither advance nor inhibit religion, and a law must not create excessive government entanglement with religion. Taken all together, this now 3-part test became known as the Lemon Test. Effectively, from this point forward in Supreme Court jurisprudence, if any law violated one of these 3 rules, it failed under the Lemon Test and it was basically considered to be unconstitutional. Sounds simple, right? Yeah, no, this didn't help at all. In fact, from this point forward, when the court tried to apply the Lemon Test, things sort of began to unravel, leading to several conflicting decisions and confusing precedent. Example A, Lynch versus Donnelly in 1984. A town square in Rhode Island had a beautiful Christmas decoration scene set up in the middle of their town square. It had Santa Claus, it had a season's greeting sign, it had a Christmas tree, it also had a little nativity scene with little baby Jesus right there in the middle. Well, several members of the local ACLU sued the government, saying that the nativity scene specifically was a violation of the Establishment Clause. Those guys are fun at parties. The court found that the display had a legitimate secular purpose, that it did not advance nor inhibit religion, and that it didn't excessively entangle government with religion, and therefore it satisfied all the factors of the Lemon Test and it was found to be constitutional. Okay, wait, I don't know what's confusing about that. It passed the Lemon Test, everything seems fine. Seems like we should keep going with this precedent. Oh yeah, I forgot. It's example B where you begin to see where the problem starts to unfold. Court of Allegheny versus ACLU in 1989. Yes, the ACLU is at it again, protecting from those dangerous nativity scenes which are hurting children and beating up grandmothers. No, seriously, just 5 short years later, the ACLU was at it again, this time trying to ban a nativity scene from a public courthouse and a menorah from a public square. The city of Pittsburgh had a large nativity scene placed in the grand entry of the county courthouse during Christmas time. Meanwhile, across town at the city-county government building, a menorah and a Christmas tree were placed together in a public square. Sounds like I'm describing a crime scene right now. The nativity scene got jealous. 2 shots were heard behind the courthouse later that night. Who's your alibi? For real, here's what happened. The nativity scene was in the courthouse by itself, and the menorah and Christmas tree were outside together in a public square. So the Supreme Court had to decide two separate issues. Was the nativity scene in the courthouse a violation of the Establishment Clause, and was the menorah next to the Christmas tree also a violation of the Establishment Clause? The weird thing was that the Christmas tree wasn't considered at all. It was just considered to be a secular whatever item that just sat over there entirely. The only thing that they were considering in the public square was whether the menorah was a violation of the Establishment Clause. I'm not making this up. So using the Lemon test, the court made the following two decisions. The nativity scene was unconstitutional, and the menorah was constitutional. How? We have 9 judges, or justices. We call them justices, but for the sake of YouTube, I'll just call them judges. And 2 of those judges, given that there were 2 rulings the court had to make, 2 of the judges flip-flopped, finding that one was unconstitutional and the other wasn't. One believed that the menorah was a non-religious symbol and that the nativity scene was. You know, the menorah, specifically the one with 9 candles representing the Jewish Festival of Lights, a religious festival celebrating the recovery of Jerusalem and the rededication of the Second Temple after the Maccabean revolt in the 2nd century BC. You know that one? Yeah, nothing religious about that. Totally good to go. The other one, Sandra Day O'Connor, said that the menorah standing alone could be conceived as a government endorsement of Judaism, but when placed next to the Christmas tree, it represented pluralism, or the recognition that there were multiple faiths and there wasn't any one particular endorsement of any one particular religion. But the weird thing about that is that the Christmas tree was never considered to be part of the case because the Christmas tree out the gate was considered to be a non-religious symbol. So how is it taking a menorah standing by itself and placing it next to a secular Christmas tree then somehow represents pluralism? So you're saying if we take a menorah, we put that next to Ronald McDonald, okay, now does that also represent pluralistic acceptance of religion? Is that not a violation? Ronald McDonald, Christmas tree, same thing, right? They're both secular. Doesn't make any sense. Also, how is a Christmas tree not a religious symbol? The Christmas tree, the Christ's Mass tree, adorned with lights and put up on the darkest day of winter to represent light in the deepest, darkest times. Its evergreen leaves representing the eternal hope brought through Jesus Christ. Not a religious symbol.
Not gonna do it. Wouldn't be prudent at this juncture.
And from this test, Allegheny versus ACLU, you can begin to see the problems with the Lemon test. Whether or not something advances or inhibits religion is subjective, and whether or not something creates excessive government entanglement with religion is also subjective. And that's why you get 2 cases, only 5 years apart, with almost the same set of facts, but wildly different outcomes. Now, of course, there are a million different nuances with each case, and you can get into the particulars of all of them, but the point is, at the end of the day, if the critical fact that's separating whether or not something is constitutional or not under the Establishment Clause is like replacing baby Jesus with Ronald McDonald in the nativity scene, then don't you think that the Supreme Court is using the wrong tools? That's my point. Because again, remember, the separation of church and state is a mechanism for protecting religious freedom. It is not the right itself, and if the mechanism isn't functioning, it is therefore becoming prohibitive of the right, making the right harder to interpret and apply, then we should adjust the mechanism. Because it's not the mechanism itself that's ultimately important, it's the freedom. So looking at this and seeing the obvious flaws with the Lemon test, the court attempted to adjust it over time without outright getting rid of it. Because again, remember, it likes to make decisions slow and deliberately over time to see how things go. Remember, jurisprudence. If you still remember that word, I commend you. Now, even from the time of Lynch versus Donnelly in 1984, the court began to add clarifications to the Lemon test in order to work out its usefulness. In Lynch, Justice O'Connor established the endorsement test, whether a reasonable observer would view the government action as an endorsement of religion, favoring or disfavoring one religion over another. If the action is viewed as an endorsement, it is likely unconstitutional. The court then added another test in 1992 in a case called Lee versus Weissman, which is called the coercion test. The coercion test was used to determine whether a rabbi giving a non-denominational prayer at the commencement ceremony of a middle school was unconstitutional. The coercion test asks literally whether a government action would pressure individuals to participate in a religious ceremony, even if the ceremony itself is voluntary. The problem with the coercion test and the endorsement tests, however, is that they were both attempts to clarify the Lemon test without getting rid of it, but all that they really did was add somewhat competing approaches to the precedent that had already been established. The endorsement test was used in the nativity cases we talked about previously, and as you can see, there were two different outcomes. And the coercion test was used in two other cases, one where a student-led prayer was voluntary before a football game, and that was found to be unconstitutional because of coercion, but also a prayer before a town hall meeting was found to be constitutional. I'm confused.
What the is this?
Anyway, the point is that these clarification tests only served to show how the separation of church and state was being decided with a certain amount of ambiguity. And that fundamental fact wasn't good for jurisprudence. So in 2022, the Supreme Court abandoned the Lemon test and the offshoots in an attempt to create a more stable approach going forward. They did this to improve the mechanism of the separation of church and state so that it more directly and consistently protects the right of religious freedom. So they adopted what is known as the history and tradition test, which asks one simple question. Is a law consistent with the country's long-standing historical traditions and the understanding of the Constitution at the time it was written? If the answer is no, then the law is probably unconstitutional. The purpose of this approach is to remove the ambiguities inherent in the Lemon test and its offshoots, especially in core natural rights areas like religious freedom. While the history and tradition test had been bubbling up in earlier cases, it became the official doctrine with respect to Establishment Clause cases when an assistant high school football coach from Bremerton, Washington named Joseph Kennedy lost his job after kneeling to pray after a game. In its ruling, the Supreme Court officially stated that it was abandoning the Lemon test and going with the history and tradition test. So here's what happened. For several years, Kennedy worked for the district, and he had a long-standing tradition of offering a silent prayer midfield after a game. Nobody had a problem with this, and it went on for like 7 years. And over time, players and members from both teams began to voluntarily join him. When they asked if they could offer prayers or even outspoken words of encouragement to players of the other team or to some of the coaches, Kennedy said, "It's a free country, do what you want." No one was asked to participate. Kennedy didn't go around soliciting players and other coaches to join him in a prayer circle. It was just one of those things that happened. And then in 2015, the superintendent of the school district for which Kennedy worked found out about the practice when someone from another school district made a positive comment about the practice after the games. So naturally, what do you do when somebody says a complimentary thing about somebody that works for you? You go and you shut it down.
No! God, please, no!
Hey, you know that thing that the other districts are perceiving as a very nice thing that we're doing for our people and our employees? Yeah, stop doing that. You can't make this up. No, for real, the superintendent found out about this and then immediately sent Kennedy a letter saying, to resolve the tension, free exercise rights must yield so far as necessary to avoid school endorsement of religious activities. So Kennedy wrote back asking the district if he could please engage in private religious expression because of sincerely held religious beliefs. Kennedy explained that he neither requests, encourages, nor discourages students from participating in prayers, but only sought the opportunity to wait until the game is over and say a short, private, personal prayer. The district responded with an ultimatum, saying that any overt action which could be seen by a reasonable observer as the endorsement of religion by the school district was not allowed, and that the only option for Kennedy was for him to pray behind closed doors in an area that was not visible to either students or the public. So after receiving this response, after 3 games, Kennedy went to midfield, bowed his head, and in silence said a short prayer and then got up and moved on. He did this 3 times, and it was those 3 times that got him fired. Well, the district didn't fire him. They placed him on administrative relief and then gave him a poor performance review and advised against hiring him the following year, and at that point Kennedy did not return and sued the district. The court found that the Establishment Clause does not allow a government to take a hostile view of religion, especially when considering personal rights such as freedom of expression and free speech. So they got rid of the Lemon Test, and they replaced it with the History and Tradition Test. Now let's break this down in light of everything we've talked about. The Kennedy case is interesting because it seems to place free exercise in competition with the Establishment Clause. The district was so paranoid about violating the Establishment Clause that they began to actively discourage participation of religious exercise, telling a coach that a silent personal prayer must be done behind closed doors, away from students, and out of view of the public, and that there's no other option that's available to them, seems to be actively discouraging religious exercise. And this is where the scales of justice begin to be weighed. You see, the First Amendment and the 5 rights that are inherent to it are supposed to be complementary to one another, not competitive. And if at any point one of those rights becomes competitive to several others, then the court almost every time is going to value the weight of the several others over the individual right that has now become competitive to the others. And that's exactly what happened here. The Establishment Clause was at odds with free exercise and free speech, and the violation was minor compared to the violations under the Free Speech and Free Exercise Clause. So the court took those weights, they compared them, and they said, well, this one is more important. And honestly, I think they made the right decision here. At the end of the day, there is nothing abnormal about players and members from a team getting together and offering a prayer after a sports event. If the previous rule on how we interpreted separation of church and state was whether a reasonable observer could see that as an endorsement of religion by the government, you put yourself down a road where now you're just based on what is a reasonable observer. And we can see it right here in the case of Bremerton. The interpretation of that reasonable observer rule became so strict that the neutrality with which the school district thought it was supposed to apply meant basically an outright punishing of anyone engaging in any form of religious exercise. That is not the way that the separation of church and state was supposed to work. And if that's the tool that's being used and that's the outcome that's happening, then it seems like it makes sense why the court chose to move away from this. Sonia Sotomayor had a lot to say about that in her dissent. She literally put photographs of the coach and other members of the teams bowing their heads together and praying as evidence in her dissent, as if it was some kind of dangerous testament that was coercing and endorsing other people to be part of the prayers.
Yeah, and here we have the bad actors engaging in their dangerous prayer circles, which might peer pressure other students to pray. And well, we just can't have that.
What the hell, man? Anyways, such a strict interpretation of the separation of church and state was ultimately leading us down a road where we were prioritizing the mechanism over the very right it was designed to protect. The separation of church and state means no government coercion or control of religion, not outright banishment of religion from all forms of public expression. Because at the end of the day, America is a nation whose laws are founded upon theistic moral principles, and to say otherwise would be incompatible with everyday life. You might not like that, but if you're interested in the truth, that's the truth. You might not believe that God created an eternal moral order that's inherent to all creation, and that we can reason our way to understanding this moral order because we're created in the image and likeness of God. Look, you might not believe all that, but knowing that it is the bedrock upon which this whole thing is built comes in pretty handy. And we should be accepting of the idea that occasionally our laws and our application of these laws will bear this influence. Now, don't freak out. That doesn't mean that we are by law a Christian nation, and it doesn't mean that the separation of church and state is eroding and being dismantled and the very fabric of our democracy is coming apart. But if at any point a doctrine becomes an enemy of the rights it is designed to protect, then it's our responsibility to modify that doctrine so that the rights remain absolute. This makes the application of jurisprudence more consistent over time, which creates a more stable judicial system, which creates a more stable society. We should want that at the end of the day, not be freaking out because it's happening. Wonderful. Good. I'm glad we got that cleared up. Now we can go back to fighting about everything else, like children, myself included. If you've watched this far, thank you for watching. I appreciate you. Consider subscribing if you've seen this video and liked it, and let me know in the comments below if you have other ideas you'd like me to break down, explain, and carry on about. I appreciate you, and I hope you're having a wonderful day, and I will see you on the next one.